Well, thank you so much, Doug, for those kind words. And thank you to everyone on the planning committee for this opportunity. I love what I do and I love to be able to talk about what I do. So I really appreciate the opportunity. And thanks to those of you who were in attendance who sent in questions before the presentation. That was really helpful as I kind of honed what I was going to be talking about. And I hope to answer most, if not all of them over the course of the presentation, and then happy to address any other questions that come up at the end. So I've got a PowerPoint that I'm about to share with you, and it's got about a probably 20 to 30-minute presentation about the basics of estate planning and what it is that we're talking about when we talk about estate planning. And then also includes the questions that were sent to me before the presentation, and so I'll go over those as well. And then, like Doug said, we'll happy to open it up for other questions. So let me get started with the screen share. There we go. So hopefully you guys can see that.
Yes.
Okay, great. And just going to, there we go. Skip those first couple. So like Benjamin Franklin said, there are two things in life that are certain, and one of them is death. Unfortunately, what we find is that most people, either because it's uncomfortable to talk about or think about, never get around to planning. And so 7 out of 10 people in North Carolina who pass away don't have a plan in place for what will happen to their assets, who will be in charge of managing their final affairs. Several reasons for that. I think the number one is that even though, none of us plan to die tomorrow, we don't know when our last day on earth is. And so we just kind of have this thought of, I'll get around to it one day. And a lot of times what happens is one day becomes too late. I'll never die. That one I really can't do a whole lot about. If you're going to refuse to kind of foresee the inevitable. But this one is one that's possibly the most egregious. My family knows what I want. We see a lot of disputes on the estate planning or estate administration end of things, because let me tell you, when money is involved, memories get short. So I would not rely on just orally telling your family what you want to happen. I believe in putting it down in writing. People often procrastinate until it's too late. Misconceptions are also a big problem that we see. A lot of folks don't understand what estate planning is or what the importance of it. So one of the things that I want to address today are some common estate planning myths and what the truth actually looks like. So here's the one that I see most often. I don't need an estate plan because I'm not wealthy. And a lot of people confuse estate planning with estate tax planning, which, given the really high current estate tax exemption, you're right, truly is for the wealthy. But estate planning is about so much more than tax planning at the end of your life. It's really about making sure that your wishes and goals are accomplished at the least possible cost. And for some people, we're talking about financial cost. For other people, we're talking about emotional cost. Usually we're talking about both. And it's really about giving you peace of mind. You have options when it comes to handling your wealth when you pass away. One option that I sometimes hear from clients is, I plan to spend it all. I don't know if you guys have a financial advisor lined up to give a presentation, but they would probably caution you that that's not a really good option. You can die intestate. And the intestacy statutes are basically the statutes that North Carolina has in place about who can handle your final affairs as your administrator and who will inherit from you if you die without a plan whatsoever. And a lot of times the plan that the state of North Carolina has isn't the plan that you would want for yourself. And the common example that I give is a young married couple, recently married, no children yet. Husband passes away tragically in an accident. Most young, recently married couples that I would work with would say, well, if I die, I want my wife to inherit everything that I own. She's going to need it to pay the mortgage and, kind of maintain her lifestyle. But the state of North Carolina says if that happens, half of that husband's assets go to the wife, the other half go to his parents. And so that's not generally the plan that most people would want, but that's the plan the state has in place for someone in that situation. I don't know about you. I don't think the North Carolina legislature is doing a fantastic job handling their own resources, I don't want them managing the resources that I have to leave behind and making decisions about where those go and who's going to manage them. Another big one that kind of, is related to myth number one is that estate planning is only about death. And that's absolutely not true. It's certainly part of what we do, but another big part of what we do is planning for your possible incapacity. We know you have a 100% chance of dying, but you've got about a 50% chance of going through some period where, because of a physical or mental illness, you're not able to make decisions for yourself. And so we need documents in place naming people that you trust to make decisions for you. To give you an example of what that looks like, I like to tell stories. And so I'm going to tell you a story about the Addams family, which are like most of our clients at the office. They're a married couple. They've been married for 40 years. They have 2 adult children. So Donna is basically the perfect child. So straight A student, president of the student body, varsity athlete, got a medical degree from a top university. She's now a research physician down in Atlanta. She's doing very, very well. They've got another daughter, Christy. So Christy is the party girl. She is a high school dropout. She's dabbled with some substances, had a couple of run-ins with the law, fell in with the wrong crowd, can't hold down a job, and she lives in Don and Jean's basement. So that is the family. It's like a lot of families that we work with. If Jean has a car accident and suffers injuries so that she's not able to make decisions for herself, we're going to have a big problem, even though they've been married 40 years. So she's in a wheelchair. They live in a home that's right here in Durham. All the bedrooms are upstairs. And Don would really like to sell that house to buy something that's more handicapped accessible, a 1-story ranch house. He assumes that because the house is owned jointly by he and Jean, that he should have no problem doing that. But he goes and talks to a realtor about putting the house on the market, and the realtor says, guess what? Because Jean's name is on the title, unless she can sign the paperwork to list this, I can't help you. And so we've got a huge problem. Don assumed that he would be able to manage everything for Jean because they've been married for as long as they have, but that's actually not legally the case. He's got a couple of other problems. So a big portion of their wealth, like a lot of us, is tied up in retirement accounts. And Don needs to access Jean's retirement account to pay for her medical bills. He can't do that. Jean's retirement accounts are owned by Jean, and only Jean has access to them. He needs to talk to insurance companies to find out about her medical bills and get, information about specialists that she's able to see. But he keeps running into problems with finding out information because of HIPAA federal privacy rules. So lots of problems. He is ultimately going to be able to get authority to make decisions for Jean, to make medical decisions for her, to access her IRA, to put the house on the market and sign the listing contract for her, but he's going to have to go through a court process called guardianship in order to do so. So guardianship is really a 2-step process. There's a hearing before the clerk of court in North Carolina to determine whether or not Jean has capacity. And in this case, she would probably be deemed to be incapacitated. And once she's deemed incapacitated, the clerk of court will name someone as her guardian to make decisions for her, both personal and financial. Here, where we have a spouse and they've been married 40 years, it's a happy marriage. It's pretty obvious that she's going to name, the clerk of court's going to name Don to serve as guardian for Jean, but it's still a huge hassle to deal with. The court is in control of who's going to be named as guardian. It's expensive, just like any time you deal with the court process, there are court fees, not only upfront, so there's a filing fee upfront to initiate the guardianship. Once Don is named as the guardian, before he's going to be able to access her assets, he's going to have to post a bond. And then every year he's going to have to renew that bond, and he's going to have to file an accounting with the clerk of court showing what he's doing with her assets. And there's going to be a filing fee every year that he has to do that. So it's not only a fairly monumental upfront cost, but it's a ongoing cost every year for the rest of Jean's lifetime. You want to avoid that if you possibly can. It takes time, again, just like any other court process. It's going to be time consuming to get a hearing date scheduled. I've had guardianships, that were filed right at the beginning of COVID that are still awaiting a hearing as hearings get pushed off. And the ongoing hassle of dealing with the court process, and to the extent that Jean has any capacity, it's humiliating to drag her to a court hearing before a clerk of court where they're questioning whether or not she has the ability to make decisions for herself. So lots of problems with guardianship. So what happens down the road? Jean's still alive, but she's still incapacitated when Don starts to show some signs of dementia. And now he can't make decisions for himself. As much as the hassle was for Jean's guardianship, at least it was fairly minimal because we knew that Don was going to be the one named as her guardian to make decisions for her. But in Don's case now, we don't have a spouse. We have 2 adult children who are both going to be duking it out to be put in charge of Don's money. And while most people would assume that Donna, the responsible daughter who's got a great job down in Atlanta, might be named as the guardian pretty easily, that's actually not the case. Christy's got a really good argument. She's going to say that Don has dementia and he needs somebody local who can drive him to doctor's appointments and, talk to the pharmacist about his medications. And, she's living right there with him. And so it's much, much easier for her to be in charge of Don's care than her sister, who has a busy job down in Atlanta and might make it up to visit a couple of times a year. So Christy has a fairly decent argument to be named as Don's guardian. But the bottom line is you don't want a clerk of court to be in control of which child is going to make decisions for you. You want to make that for yourself. And this is going to be even more expensive than Jean's guardianship because Donna and Christy are both going to hire attorneys to try to prove why they should be named as Don's guardian. And it's just going to be an absolute nightmare. And it's going to take a long time before anybody's in place. So we want to avoid that. The way to do that, there are 4 documents, well, I should say 3 documents that everyone over the age of 18 needs. One is a general power of attorney. So that names somebody to make financial and legal decisions for you if you're alive but incapacitated. Then there's the healthcare power of attorney. Names somebody to make healthcare decisions for you if you're alive but incapacitated. And the healthcare power of attorney, you can specify treatments that you don't want or you want to be off the table. So you can make some specifications there. And a HIPAA authorization. So what friends or family members do you want to be able to talk to your physicians and have access to your protected health information? Everyone over the age of 18 needs those 3 documents. My son, who is now 20, the day after his 18th birthday, I dragged him to the office and made him meet with one of my partners to get these documents in place. It's absolutely vital. The last one on here, the Advance Directive for a Natural Death, that's not a required document, but what that allows you to do is say that you do not want to be kept alive artificially if you're in certain very narrow end-of-life situations. And most of my clients would want that document either because they feel strongly about it or even just to take the burden of making that decision off of their family members. So those 4 documents can get you out of guardianship and put people that you trust in place to make decisions for you if something should happen and you can't make them for yourself. So myth number 3 is a simple plan is always the best. I've never had anyone come into my office and say, I want a plan with all the bells and whistles, make it as complicated as you possibly can. Everybody comes in saying, I just want a simple plan. But life is not always simple. And so let's go back to the Addams family to talk about some of the concerns that they have that might require their plan to be not quite as simple as just everything to everybody outright. So the most important thing is that your plan is custom tailored. So they're worried about if one of them should pass away prematurely, will the surviving spouse get remarried? And if the surviving spouse gets remarried, will the survivor leave everything to that new spouse? Will they leave out the children? I've had that happen in my own family. My Aunt Vivian passed away. 8 months later, her husband was remarried or was engaged. A year later, her husband or her, now husband was remarried. When he passed away a few years later, he left everything to the new wife. Vivian's children got nothing. Most of you have probably seen that happen among friends or family members. So if Don and Jean are worried about that happening, their plan might address that. What happens if Jean passes away and then Don gets remarried? How can we protect Donna and Christy from Betty, his new wife, in this scenario? While Donna is making wonderful financial and educational and business decisions, she is not making as good decisions in matters of the heart, according to Don and Jean. She is married to Jimmy, her lazy husband, who, once they got married, quit his job because he figured Donna could just support him. Doesn't treat her very well, doesn't contribute financially, emotionally, otherwise to the household. And Don and Jean just kind of assume that at some point Donna's going to see, the error of her ways and she's going to divorce Jimmy. Well, they're worried about what's going to happen if they both pass away. Donna ends up with half of their assets via an inheritance, and she's going to put it in a joint bank account with Jimmy. They get divorced. Jimmy walks away with half of Donna's inheritance. So how can we protect against that? What about Christy? For Christy, we're concerned about her own life choices, right? So first thing Christy is going to do when she gets her inheritance is she's going to run out and buy a sports car. Then she's going to go to the bar and she's going to have a few too many. She's going to get behind the wheel of the car and cause a car accident. She's going to run into a bus full of personal injury attorneys who are going to get every last penny that she owns, including her inheritance money. So if we've got somebody like this in our family of Christy, maybe the simplest solution is to give everything to them outright, but that might not be the best solution for them in terms of protecting them from their own possible poor life choices. So what might we do for a family like the Adams? Well, we can protect against Don's remarriage. We can protect against Donna's divorce. We can protect against Christy's poor choices with a trust-based plan. And so what that would look like for this family is we set up a revocable living trust. Don and Jean have complete control over and access to the assets while they're both alive. When Jean passes away, the trust gets bifurcated into two. So Don's half of the assets go into what we call a survivor's trust that Don has complete control over and access to. If he wants to leave his own money to Betty, he should be able to. It's his money. But Jean's money gets set up in an irrevocable family trust. And the family trust can provide for Don, can let the trustee use the money for his support, his maintenance, his health care. But when Don later passes away, whatever's left over in that irrevocable family trust is going to go to Donna and Christy. Don cannot divert that money over to Betty. For Donna, we can protect her inheritance by putting it in a trust for her that she's the trustee of, because financially she's making great choices. So she can manage that money. It's for her benefit, for the benefit of any children that she has, but it's kept segregated from her marital assets and it's protected in the event of a divorce. For Christy, we put the money for her in a trust, name some third party to serve as trustee and manage that, and dole it out to Christy a little bit at a time as she needs it. For someone like Christy, we might put some incentives in. If she can prove that she's held down a job nonstop for 3 years, she can become her own trustee. If she goes back to school, finishes college, and gets her bachelor's degree, she gets a one-time lump sum payout from the trust of $50,000. So what behaviors would we like for someone like Christy to engage in? And what incentives can we build within the trust to encourage those behaviors? And who should be managing this money for her to prevent her from squandering it or from it being taken in lawsuits or by creditors? So not a simple plan that the Adams have here, but it's one that addresses their concerns more so than just leaving everything to the surviving spouse and then to the adult children outright. Other wrinkles, minor children. So anyone under the age of 18 cannot inherit outright. And so if you don't have a plan in place for one who's going to manage their money until they're of age, and two, who is going to have physical custody of them, you're setting yourself up for not only a lot of cost, because the court's going to be involved again, just like they were under the guardianship of an incompetent adult. Court's going to decide who they get to live with, and the court's going to monitor or oversee their inheritance, and every year whoever's in charge of that money is going to have to file accountings until they're 18 and the money gets turned over to them. I have a 20-year-old, love him to death. He is a great kid. I cannot imagine him being mature and responsible enough to handle a significant inheritance at 20, much less 18. So this often isn't the best plan never is the best plan for minor children. And so you want to be very thoughtful, even though it's not simple, about how you're going to leave money and who's going to be in charge of an inheritance for anyone under the age of 18. Blended families. I'm part of a blended family myself. My son is from my first marriage. I'm now married to my second husband. Love them both, but need to be very thoughtful. What do I want to do for my husband? What do I want to do for my son? And how can my plan reflect those values that I have, that I want to provide for my husband in the event of my untimely death, but still protect the inheritance that I ultimately want to pass on to my son? So when you have a blended family, you've got to be even a little bit more thoughtful. So what happens a lot of times that I see is Mike passes away, leaves everything to Carol. Carol passes away. If she doesn't have a plan in place, the intestacy statutes would say everything goes to her 3 girls. Mike's 3 boys end up with nothing. So even if the plan is I trust my spouse to distribute the assets equally among all 6 children, you still need a will, a trust, some document that says that. Otherwise, the children from the first spouse to pass away just get left out in the cold. Special needs protection. So if you have any beneficiaries who, because of a disability, are receiving needs-based government benefits like SSI or Medicaid, you have to be very thoughtful about the way in which they're going to inherit to protect their eligibility for those benefits. And there are certainly options for that, but you have to be proactive in setting up a plan for any beneficiary whose own government benefits. Myth number 4, and I promise these last 2 are a little bit faster. Next one is it's all about the legal documents. So a lot of people assume that because they've had a will drawn up, either they've done one on LegalZoom or they've paid an attorney to draw one up, that they're fine. That's all they need to think about when it comes to their plan. But there's really so much more to the documents. There's things like your family dynamics. So I had someone come into my office, or I should say by Zoom meeting, a couple of weeks ago, and you know, it's a older lady, widowed, and she has 2 adult children, and she said, can I name them both as co-executors? I don't want to play favorites. And the answer is yes, you absolutely can. But the next question is, tell me about your sons. You know, they're both doing great. One's a financial advisor, one's a doctor. They're both very successful, mature, responsible. So far, so good. How do they get along? They can't stand each other, haven't talked in years. Probably not the best decision to name them as co-executors, because they're not going to be able to work together to handle your final affairs. Frankly, probably not the best idea to name either of them as your executor, because that's just going to create conflict. So what are your family dynamics? And that should factor into how the plan gets drawn up as well. Your property, I'm going to talk about that in a second. Your values. And so, you know, it might not be that you want to leave everything to your family. Maybe you want to leave a legacy to charity. So what are your values, and how should that be reflected in the way your documents read? What are your goals for your assets and for your family, and much more. And the biggest piece is that your documents don't control all of your assets. Life insurance and retirement accounts are, you know, 2 big assets that most of us own, and those are going to pass by beneficiary designation. Doesn't matter what your will says. So for my retirement account, my life insurance, even if my will says give everything 50-50 to my husband and my son, if my ex-husband is still named as the beneficiaries of those policies, guess where that money's going? To my ex-husband. So we've seen inheritance go awry because beneficiary designations didn't get updated at the same time as the will got updated. Same thing, deed to your home, owning assets jointly with right of survivorship. This one is one that I've seen happen a lot, where an older client goes to the bank with their adult daughter and says, I'm starting to need some help with managing my money and I can't get out and about like I used to. I want to add my daughter to my account so that she can write checks and pay bills for me. And that banker is just going to go into the computer and add the daughter as a joint owner to that bank account. That's just kind of what we see bankers do. Not asking, well, is your daughter a power of attorney so that we can add her to the account that way? They're just going to add the daughter to the account. Well, when mom passes away and the will is read and the will says give everything 50-50 to my daughter and my son, that account that's joint with right of survivorship with the daughter is going to go off the top to the daughter. So daughter ends up with more money than the son does. And we get an angry phone call from the son in our office. And so you want to be very careful about owning things jointly with right of survivorship because will's not going to control anything that has a contract that says goes to the surviving owner. Same thing with pay on death, transfer on death designations can be a wonderful tool, but proceed with caution because you really have to read the fine print. So 3 key estate planning questions. If you go talk to an attorney about setting up a will or a trust or any version of estate planning documents, they should absolutely be asking you about your assets. What do you own? How do you own it? What is it worth? We need to be able to give advice about making sure beneficiary designations are consistent with what the will or what the trust says. Can't do that unless we know what the assets are that we're dealing with. So vital questions in any estate plan. And then the last myth, and this is a quickie, is that I already have an estate plan, so I never need to think about it ever again. And that's just not true. We say estate planning is a process, it's not an event. Changes in your family, your health, your wealth, your preferences, all might necessitate changes to the documents. I've reviewed wills that are 20 years old, and every person that was listed as an executor or a beneficiary has since passed away. Might as well not have a will in that case, right? So you want to make sure that the documents stay updated to reflect any changes in your family or situation. So, and now I would open the floor to questions, but since we already have some questions, I'm going to address those first. First one, we had several questions about charitable giving. So first, I want to talk about what's the best way to give to charity during lifetime. And a lot of times it's not just writing a check. The most tax efficient way, if you're over 70 and a half and born before 1949 or 72 and born after that, because we just had a slight change in when you have to start taking out required minimum distributions from retirement plans. But if you have to take out required minimum distributions from your IRA, 401k, retirement plan, best way to give to charity is by directing the custodian of your retirement account to send your required minimum distribution or a portion of it directly to the charity that you want to benefit. Because if you do that, you don't have to recognize the income from that required minimum distribution. So saves you a lot of money on the income tax deal. Another option, and if you're not old enough to have retirement accounts or don't have money saved in retirement accounts, is donate low basis stock. So if you have stock in a company, you bought it for $5,000, now it's worth $8,000. If you sell it, you're going to pay capital gains tax on that $3,000 that it's gone up in value. And then you can write a check to the charity, but it's going to be, you know, less that probably 25% federal and state rate on that $3,000. So you're, you know, losing a fair amount of money by selling the stock, recognizing income taxes, and then making the distribution. If you donate that stock directly to the charity, you don't pay capital gains taxes on it. Charity is not subject to income taxes, so it's win-win for both of you. You can get more money to charity that way. Same thing, donate non-income producing assets. So if you're looking to make a gift, look at the things that you don't need anymore, like maybe a life insurance policy. Your kids are all grown up, don't really need that anymore, and it's not producing any income for you. So might be anything that's not producing income might be another place to look to make a donation rather than cash. Cash is great, but there are ways to get more to the charity in a more tax efficient way, particularly with IRAs and low basis stock. At death, similarly, the absolute best way to leave money to a charity is by leaving them money from your tax deferred retirement account, especially with the passage of the Secure Act in December, which limits the ability of most beneficiaries to stretch out distributions from an inherited retirement account to 10 years. If you leave, let's say, $10,000 from an IRA to your adult children, by the time they pay federal and state income taxes, that $10,000 to them is probably only worth about $6,000. But if you leave that $10,000 to charity, because charity's not paying income taxes, $10,000 is worth $10,000. So when we have both people beneficiaries and charitable beneficiaries, we want to leave the people cash, real estate, other assets that are not subject to income taxes, and want to leave charities money from retirement accounts or other tax deferred vehicles. Obviously, you can also include a gift in your will or your trust, but really look first at making gifts to charities from your retirement accounts. Another benefit to this, and someone I think could ask a question about this, is that this doesn't involve paying your attorney any money. If you want to add a charity to your plan, if you go in, and a lot of us can do it online, amend the beneficiary designations for retirement accounts, you can log into your plan, add that charity, leave them 5%, 20%, 75%, whatever the number is, and that's adding a charity to your plan without paying an attorney to update your will or your trust. And so saving you both legal fees as well as saving your family on the back end income taxes. There are other vehicles that I'm not going to get into during this presentation because I want to make sure I have time for your additional questions, but there's charitable trusts, there's donor advised funds, there's private foundations. There are other more sophisticated tools for making charitable gifts, which I'm happy to go into. If anybody has questions about those, probably more in a one-on-one meeting. I had a couple of questions about which one's right for me, a will or a revocable trust. Both are going to ensure that you get to choose your beneficiaries and you get to choose the person who is tying up your final affairs. So both kind of accomplish that goal. The big benefit of a will is that it's going to be more expensive upfront to set up than a trust. And with a will, you don't have to retitle your assets usually. The drawback really is that you're going to go through the court process of probate when you pass away. So that can be expensive. So there's a fee to file probate, $120 in North Carolina. You have to publish a notice to creditors in the newspaper, which is going to be a few $100s depending on the county where you live. And then there's a fee based on the size of your estate, so 0.4%. So if you're dealing with a $500,000 estate, that's $2,000 probate fee right there off the top, in addition to a couple, $500 or so in other fees. So it can be more expensive on the back end than setting up a trust would be on the front end. Another big one is a loss of privacy. So your will, once it's probated at the clerk of court's office, is a public document. Anybody can go down to the courthouse, read your will, find out, who you're leaving things to and how. The inventory of your assets, which is due 90 days after the probate is initiated, is also public record. So anybody can go down to the courthouse and review that inventory and find out what you were worth when you passed away. A lot of folks don't like that loss of privacy after their passing for themselves or for their family who's going to inherit from them. So that's another drawback. possibility of multiple probates if you live here in North Carolina and have real estate somewhere else. So timeshare in Florida, beach house in Myrtle Beach, you're dealing with probate not only in North Carolina, but also in Florida, South Carolina, New York, wherever that other real property is located. And that can be a huge hassle and expense. So that's the big drawback to a will. So trust is going to be the opposite, right? So drawback is that it's generally more expensive to set up, and a lot of times involves more legwork on your part, because in order for it to function as we intend, you're going to have to go around to financial institutions, retitle things into your trust. But the benefit is that you avoid probate when you pass away. It makes things less expensive and easier for your family on the back end to wind up your final affairs. And it protects your privacy, because unlike the will, it does not become a public document upon your death. Only your beneficiaries, your trustee, and professional advisors that you've chosen would get to see what the trust says. So pros and cons, there's no one size fits all. Some people opt to have a will, some people opt to have a trust, but those are the big differences in terms of, pros and cons to one versus the other. Providing for pets, and obviously you guys know I have a cat that I think sometimes I love more than my husband and son, so we want to make sure that our pets are taken care of in our plan. One thing, and this is even before death, make sure you designate an emergency person who has access to your house if something happens to you. It could be your death, but it could also be an accident or something else that renders you temporarily incapacitated. But you want to make sure that someone has a key to your house so that they can go in and feed and care for your pets. Make sure that friends and family who are going to be notified if something happens to you knows who this emergency contact is. I'd post a sign near the front of your door for emergency workers. Keep a card in your wallet for emergency workers saying, in case of emergency, contact this person to take care of Atticus in my case. In your will, you can designate someone that's going to permanently take care of your pets when the inevitable happens to you. And then consider a financial gift to that person. It could be an outright gift. Here's $10,000 to thank you for taking care of my pets, and hopefully this will cover some of the cost of food and veterinary care and boarding. It could be if you want to leave a larger gift in the form of a pet trust. So that's where you set aside money, and there's the caretaker of your pets who's got physical custody of them, but someone else who's trustee, who's managing that money and doling out money to the caretaker. So we can certainly set up a pet trust as part of your plan as well. And then obviously you want to make sure that the emergency contacts and the permanent caregiver have access to vet records and any other information that they would need to make the transition as smooth as possible for your fur babies. So, what makes your pets comfortable? What's their favorite toy? What are they afraid of? So, instructions that are really personal to your pet should also be included somewhere with your important papers and shared with those contacts. Several questions dealt with choosing decision makers in your documents. And so we're really dealing with kind of three different types of decision makers. There's the executor and death trustee, so that's the person that's winding up your final affairs after your passing. There's the general power of attorney agent and incapacity trustee. So that's the person who's making financial decisions for you if you're alive but don't have capacity. And then the healthcare power of attorney. And those questions were, one, how much of settling an estate can be done by an organized and hardworking executor versus having much of it done by paralegals and attorneys? Just about everything can be done by an organized and hardworking executor. We typically, if the person that passed away was our client, recommend that the executor have at least one half-hour, 45-minute meeting with us so that we can tell them, here are the court deadlines you need to be aware of. Here are the tax filing deadlines you need to be aware of. Here are some pitfalls that people often fall into that we want to make sure that kind of you're wary of. But then after that, a lot of times a good organized person can do most, if not all, of the work themselves from there, and they might call us a time or two if they have questions. So absolutely, a dedicated, hardworking, organized person can do just about everything themselves without requiring the help of an attorney, although it's good to have an attorney at least involved in the conversation initially. Do you have an opinion on the advantages, disadvantages, wisdom of naming a financial institution as executor of a will or trustee of a trust? So a financial institution certainly brings something to the table in terms of they've done this before. They've done this before probably thousands, if not tens of thousands of times. And so, you know, they're going to be more familiar with the process. They're going to know those pitfalls to avoid. They're going to do a good professional job. The drawback is the cost. They're going to be far more expensive than having a family member or friend or professional advisor serve as trustee. And they're not going to be willing to serve unless you have a minimum amount of assets. And some of them will serve at the $500,000 level. A lot of them won't serve until you're looking at $1 million or more. So, you know, for folks that are in that bracket where it's a possibility, it can be good, but it's going to be more expensive. For a lot of the clients that we work with, it's not even a possibility because their assets don't rise to the level that a financial institution would be willing to handle. But happy to get more kind of in depth on the pros and cons with whoever asked that question if you want to kind of explore that a little bit more. For persons who have no children, few living relatives, and would like to avoid burdening friends by naming them as alternate executors, can an attorney serve as executor? Absolutely yes. If so, is it necessary that the attorney be in the same state or county? County, absolutely not. If the attorney is not in the same state, then really you're just naming them as a family friend to serve as executor, not as an attorney, because the probate process in every state is very different. If my grandmother in Virginia named me as the executor of her will, I would have to either find a Virginia attorney who could explain the probate process in Virginia to me, or I'd have to figure that out myself, just like that hardworking, organized executor that we talked about in the first question here. I wouldn't know the first thing about Virginia probate versus North Carolina probate. Sure, there are some similarities, but there are enough differences that that being an attorney wouldn't really give them a leg up on anyone else who's organized and hardworking. And how does one identify a reliable healthcare proxy when family members are not appropriate? And this is maybe the toughest one for some of my clients because a lot of us don't have family members that are appropriate. If you don't have family members, we can think in terms of friends. Some of my friends I'm closer to than some members of my family, and I would trust them more with those final kind of healthcare decisions for me. If there's no friends that you would trust, there are also nonprofit organizations that are willing to serve as healthcare power of attorney for you, and you have to pay them obviously to serve, but that is an option. You can't outsource that as well as these other jobs. Kind of final questions that didn't really fall into any specific category. If I have a trust, do I also need a will? You do, but if you have a trust, the will is gutted. It doesn't really have any dispositive provisions. It's what we call a pour-over will. It just says if there's anything that either kind of intentionally or accidentally was left out of my trust, when I pass away, pour it over into my trust at death. Is there any reason that couples who have no children, few living relatives, and intend to leave most of their assets to pre-designated beneficiary charities would nevertheless need a trust, or would a simple will suffice? There can be some advantages to having a trust in that situation. The biggest being that it's one. So if you just have a simple will, so you've got the will that says give 20% to each of these 5 charities, but then you also have to update the beneficiary designations for any retirement accounts, life insurance policies to name the same charities. So if you change the will, you have to go back and change all of these other accounts and policies. With the trust, you can name the trust as the beneficiary of retirement accounts, life insurance policies. So if you change your mind about what charities you want to name, you only change it in one place, the trust. You know, there's also the kind of cost. You know, if you've got a $2 million estate that's going to go through probate, it's going to cost less to set up a trust than it would be to run your will through probate. You know, you might not care because you're gone, and I certainly understand that. I'd rather these charities pay a little bit more money on the back end. They're getting a lot from me anyway versus, you know, me having the upfront cost. But those are really the 2 advantages: centralized management of everything to make it easier to make changes, and then it can be less money to have a trust on the back end. So it just kind of depends on what your goals are. What is the minimum requirement for a legally binding will? There are 3 types of wills in North Carolina. A typed will is required to be executed in front of 2 witnesses. If you don't have it, if you don't sign it in front of a notary, it's still valid, but once you pass away, whoever your executor is who's trying to probate that will is going to have to track down those witnesses and get them to sign an affidavit that they saw you sign. You were 18 years of age or older, of sound mind, and under no constraint or undue influence. So that can be difficult to track down witnesses, you know, years and years later in some cases. So that's for a typed will. For a handwritten will, called a holographic will, doesn't even have to be witnessed, but we'll have to find witnesses willing to sign affidavits that that was your handwriting. Last type of will is what's called an oral will, where you tell someone, you know, say in front of witnesses, I intend for this to be my last will and testament. Here's what I want to happen. That has to be in your deathbed, can't be used to dispose of real estate. And frankly, that is a recipe for having it challenged. In my over 15 years doing estate planning, I've never heard of probate of an oral will. Would not recommend trying that. But it is one of the versions that's still legally allowed in North Carolina. And then what to include in a will, what information do I need to assemble beforehand? Any attorney that you're working with should send you a questionnaire or some kind of form to fill out to get you thinking about what are some of these decision points before you have a meeting. Even if you have a meeting and you haven't thought about it beforehand, the attorney can tell you here what the decision points are, here's what information that I would need, and then you can kind of gather that and set up a follow-up meeting to nail down the details. So I would say talk to whatever attorney you're going to be working with about, do you have a questionnaire for me to start getting some of this information ready for you? And they should be able to tell you, or their paralegal, whoever you schedule with, should be able to tell you what information will be required. I apologize. I feel like I was talking very quickly because I wanted to save time for question and answer, but you guys did ask so many great questions like before this. So.
Yes, thank you, Jennifer. The stories were very clever to give examples of all this. We've got one question in the chat, and I'll ask that, but if anybody else has questions, if you would wave your hand and unmute yourself, then we can recognize you. One question, if you have a revocable trust for a child, should it be designated as the beneficiary of an IRA?
Yeah, absolutely. And you'll want to make sure that that trust for the child has what's called either a conduit provision or an accumulation trust provision. So both of those are kind of instructions to the custodian of the IRA about how that retirement account should be distributed. Otherwise, if you pay it to a trust and it doesn't have that magic language in it, then the child would have to pull out the money from the retirement account over 5 years. If you have that magic language for an adult beneficiary, you have 10 years. If you have a minor child, they stretch out in distributions over their life until 18, and then that 10-year clock starts running. So you can get more stretched out, more tax deferral if you have specific provisions in there. But as long as those specific provisions in there, absolutely, it's appropriate to name that trust as the beneficiary. So having beneficiary designations is one way to avoid probate, and it's the way that we sometimes will use. There can be drawbacks. Mm-hmm. Let's say you've got, you know, everything, all of your money is going to these 3 charities. Well, there's some debts in your estate. Somebody's going to need to be appointed as the executor or administrator of your estate to pay funeral expenses, final medical bills, right, court costs. If everything is going to the charities by beneficiary designation, you've left that person that's the executor with some debts and no money to pay it. And they're going to have to go back to the charities with hands outstretched saying, you know, that money that you got from Linda, I need some of it back. And that's just kind of a nightmare. So even if you have beneficiary designations on a lot of your assets, you want to make sure that you leave enough money for your executor to pay final expenses. The other drawback, which obviously doesn't apply to you, But when we have clients that have children and grandchildren, the way most of those beneficiary designations are set up, if you leave things a third to each of your 3 children, if one of them passes away before you, the other 2 get everything 50-50. And the children of that deceased child get cut out of that asset. And that's just kind of the default provision in most of those plans. Even if you can designate that it goes to the children of a deceased child, if they're minors, there may or may not be provisions in there about, holding things in some kind of custodial account for them until they're 18. So those can work. You just have to be very careful to read the language of the contract and to think about what are the what ifs that could happen to your beneficiaries. Generally, it's going to be a specific nonprofit that's willing to do that. The one that I'm thinking about is Corporation for Guardianship out in Greensboro. And generally, when I have clients that are looking at, having trouble naming a family member or friend, I refer them to Corporation of Guardianship, who are willing to serve in that capacity. Yeah, I don't remember what their contract arrangements are. I've looked at it in the past. I just haven't looked at it recently. I think you have to pay them in advance something, but also like once, probably a nominal amount in advance, but then once it kicks in, they get paid, I think like a monthly amount or a quarterly amount. Because it could be that you never need them. If you're naming them as your health power of attorney, and you live to a ripe old age and then die peacefully in your sleep, having retained complete control of your mental faculties, they never need to serve. And so you wouldn't want to, pay them thousands of dollars up front and they never be needed. So I think that the fee really comes into more if they are serving in that capacity. So I've seen the healthcare power of attorney and advance directive combined into one document. I don't really personally like to do that. I generally use the North Carolina statutory forms for those two, which are separate. You wouldn't want to combine a general and a healthcare power of attorney, because the general power of attorney is going to be shown to banks. You don't want them seeing the provisions that you put in place about here's what type of medical treatments that I would want. And kind of same thing, the healthcare power of attorney is going to be shown to medical providers, and you wouldn't want them to see like, oh, I had this other agent that's in, control of managing my bank account and my Facebook account. So it's just such different things. And to avoid confusion, make sure that your wishes are being honored. You want to have separate documents just because they're kind of for different purposes, without muddying the waters. The only time that we ever have to be in a guardianship scenario when we have a general power of attorney is in that rare case where we have a client who very clearly doesn't have capacity anymore. They should not be making decisions for themselves. They're being taken advantage of, losing money to schemes, but they refuse to acknowledge it and allow the general power of attorney agent to begin acting for them. In that case, sometimes the only way to protect them from themselves is to have them declared incompetent so that they don't have the legal authority to bind themselves to contracts. So that's the only scenario in which we might still have to go through a guardianship, even if there's a general power of attorney, is if someone's being taken advantage of but refusing to let their power of attorney agent help them. But in general, no, the whole purpose of the general power of attorney is to avoid guardianship. But all of our powers of attorney have a similar provision that says if a guardianship is ever needed, I want the person that I'm naming here to be named as the guardian. So we've got a questionnaire, so you can call and talk to either me or my legal assistant, Erin, and we would send you a questionnaire to fill out. Some sections of the questionnaire might not be applicable to you and you can just leave them blank. But then my legal assistant, Erin, would also send you a link so that you can, right now in the time of COVID, we're doing things remotely. She would send a link that you could upload copies of your current documents in that questionnaire to. But yeah, the questionnaire would walk you through kind of in addition to the current documents, here's what we want you to be thinking about before we meet. So once we have the initial meeting and my calendar This week is fairly booked. I've got plenty of availability next week, so you'd probably be able to get in to see me within a week, just, if your calendar jives with mine. Once we have the initial meeting, the typical turnaround time between the meeting and the signing of documents is about 4 to 6 weeks. So after we meet, about 2 to 3 weeks later, I'd be able to get draft documents out to you, and then want to make sure you have a week or two to review those. Get back to me if you have questions, concerns, changes that you want to make. And then we would meet to sign the document. So full time is like, 4 to 6 weeks, but that's time for me to draft and time for you to review. Great question, and one that we encounter quite a bit. So the two options for your power of attorney are either one, on its face, it says it's effective immediately. Like you said, it could be used early in that case. The other option is to include what we call springing powers. The power of attorney only is activated when 2 physicians have said you've lost capacity, you sign off that you're ready for your agent to act, or you can't be located, you've been kidnapped or lost at sea. I tend to recommend the effective immediately language, but the safeguard that we have in place for our client against someone acting, prematurely under that power of attorney is that we offer to hold original documents for clients. When we do that, we have all of our clients sign something called a document storage agreement, which is their instructions to me and to our firm about under what circumstances can we release copies of the documents to anybody. And for the general power of attorney, there's several options. So is it when the agent says they need it? Is it only when we have 2 physician certifications that you lack capacity, so similar to the springing powers? The option that most of our clients choose, and that frankly I recommend, is the option that says when there's evidence of your inability to manage your financial affairs that my attorney at Walker Lamb deems credible. And so that puts us as a neutral third party as the gatekeeper. We're holding the original. We're going to make sure that there's some other evidence other than just the word of your agent that it's needed before we release that to them. But it's without the onerous documentation requirement of those springing powers where you have to track down 2 physicians and get them to make statements, which takes time, frankly, and a lot of doctors are not willing to make a statement like that. So we think it's kind of a happy medium middle ground between ease of use when it is needed and protection against it being used early. Just one more thought, which is that a couple of folks had asked questions, emailed questions in advance that I didn't address. And I meant to mention this because they dealt more with financial planning and retirement planning. I am not a certified financial planner. I know just enough to be dangerous about the different financial products that are available. I know how they can fit in with the will and a trust, but I don't know what's right for you for the rest of your life in terms of financial planning. So I wasn't really able to address those during the presentation, but it is an occupational hazard that I know a lot of financial advisors being in my field. And so if anybody would like a recommendation to a financial advisor to address those questions, would be happy to send you some names of folks that might be a good fit. So please feel free to email me and say, hey, I'm one of those people with the financial advising question. Who would you recommend? And I'm happy to give you a referral to someone.
Okay. Well, Jennifer, great job. Thank you. I thought I knew a lot, but I learned a whole lot today. And just to reiterate with everybody, first of all, thank you for joining us, but also I'll be following up to give you Jennifer's direct contact information if you have any further questions. So thank you so much, Jennifer, for your time, and everybody for joining us. All right.
Thanks for having me.
Yep. Bye-bye, everybody.